on the e-cigarettes ban caught a challenge today, and the challenge to reopening of schools. She joins me now via Skype. A very good evening to Karyn. Thanks indeed for your time. So look, FITA's main argument, it seems, is that the Disaster Management Act does not empower the minister to enact regulations which ban, amongst other things, the sale of cigarettes. What aspects did FITA's lawyers argue, that the minister failed to consider before the decision on the ban was made?
Well, essentially, they're arguing, Griselda, that you need to show a substantive link in rationality between the banning of cigarettes and the desire to stop the spread and severe outcomes of COVID-19. And they're saying that the minister has simply failed to do so, that the so-called medical evidence on which she's relying, primarily a document by the World Health Organization, is itself inconclusive, that there is simply no conclusive evidence at this point that states that smokers are somehow more at risk, for example, than other members of the population, particularly in circumstances where these kind of risks are shown to exist, for example, with obese people or diabetics. They're also saying that this has had a devastating impact on the South African economy, that everyone from the farmers who farm tobacco, the people that they employ, logistical people, the tobacco manufacturers themselves, that this entire industry has been decimated, and it has severe economic consequences. And they're also saying that in light of the fact that government has chosen to lift the ban, for example, on alcohol, there are some really strong questions about the rationality of it continuing with tobacco, given that South Africa is one of only 2 countries in the world that actually has a cigarette ban in place as part of its COVID-19 lockdown regime.
Karyn, so one of the other issues is that we heard that the minutes of the meeting which took the decision to ban the sale of cigarettes are classified as secret. So what remains interesting is the president's failure to explain, saying on the 23rd of April that the sale of cigarettes would be allowed under the next level, and then a sudden U-turn, isn't it?
Well, this was a big issue that was raised by the FITA advocate Arnold Subel in court today. He said, the president has actually failed to provide an affidavit to say, look, after consultations, this was the evidence I considered, and this was how I came to my decision. And they say that, this evidence, the medical evidence that the minister relies on now, Dr. Nkosazana Dlamini-Zuma, must have been before the president at the same time on the 23rd of April. Why is it that, he would have then made such a radically different decision? Of course, the state saying it's not necessary for President Cyril Ramaphosa to explain himself, that the affidavit filed by the Secretary for Cabinet, Dr. Cassius Labisi, was enough. That they aren't required, there is no requirement on the president to file any such affidavit, and very much disputing any suggestion, which of course has permeated a lot of the analysis and public discourse on this, that somehow Dr. Nkosazana Dlamini-Zuma was overriding the NCC and the president when she announced, in fact, just days later, that the tobacco ban would not be reversed.
Karyn, I see FITA's lawyers were describing the ban as a sledgehammer to beat people into submission, and basically arguing, like you indicated, that there's not enough evidence to prove that smoking increases the severity of COVID-19. I want to talk about another issue now. So you also have Dr. Nkosazana Dlamini-Zuma's lawyers filing an application for leave to appeal the High Court ruling that declared regulations in respect of level 4 and 3 irrational. Government in those papers saying that the decision is unjustified, and that Dr. Dlamini-Zuma was denied her right to a fair hearing. Tell us more.
Well, essentially what they're arguing is that the court went beyond the parameters of the papers that were filed by the applicants in this case, the liberation fighters, and that essentially they weren't given an opportunity, or she wasn't given an opportunity to, in particular, defend the Regulation 3 regulations that were put in place with Alert Level 3, because those regulations were in fact promulgated and released on the day that the court heard this case. So, of course, she wasn't given an opportunity to defend them. Instead, the court just declared them unconstitutional and then referred all these regulations back to her for reconsideration within a constitutional ambit. And they're saying that simply isn't fair. They're also saying that, that she should have, that the orders are vague. The court they're not entirely sure of what exactly she must correct in these regulations. And that, this has far-reaching implications for all South Africans. And this is why it must be urgently appealed in the Supreme Court of Appeal. But what joins the thread here, of course, is that government is currently facing 9 other court cases with regard to the National Command Council that, of course, formulates a lot of it is in fact constitutional and lawful, and to the regulations themselves. There are a number of other challenges to the rationality of the regulations and whether the public were actually consulted over them. The FITA case goes again to the heart of that. Again, it's a question of, are you banning cigarettes in a way that is rational, that stops the spread of COVID infection, that stops the severe outcomes of COVID infection, or is this yet a manifestation of irrational decision-making on a part of a state that is abusing the power it has in a very difficult situation for all South Africans?
Karyn, does this in any way point to perhaps a government with these challenges that are all now going to court, point in any way to perhaps, a government not being cognizant of the fact that even though it was necessary for the lockdown to be instituted in South Africa to ensure that there is no further spread of or rapid spread of the coronavirus in the country, it doesn't outweigh the constitutional rights of South Africans in the country. Talk to us a bit about that and how government finds itself in between a rock and a hard place, if I can.
Well, this is one of the main points. I mean, it came out very much in that judgment that Nkosazana Dlamini-Zuma is now trying to appeal. The judge in that matter, Norman Davis, saying he couldn't rationally understand why, for example, a hairdresser would, not be able to put food in the mouths of her children by earning a living while using protective gear, while, adhering to all her safety standards. But, a number of people could get into a minibus taxi in circumstances where they would probably be far more close together than they would be in a hair salon, saying that, why would people, someone's dying relative would not be, family members couldn't, visit their dying relatives, but then 50 of them could converge and potentially cross provincial lines to attend that relative's funeral once they were dead. So these were very commonplace questions that he asked. I mean, his whole judgment is a series of questions, of course, the state disputing that, but a manifestation of a level of public frustration and arguably, Griselda, a failure by government to really take the nation into its confidence and say, this is what we're trying to do. This is what we're trying to explain. Now, of course, there has been about we have seen in the last few days just huge amounts of affidavits being filed by the state to explain, even, for example, the restrictions on clothing. Ibrahim Patel has filed an affidavit on that matter. But the government, as much as it needs to win these legal cases, also needs to win back in the court of public opinion, where many South Africans are simply frustrated by what they perceive to be irrational, unfair, and ultimately unconstitutional regulations that have severe impact on them and in many instances their ability to earn a living.
Sure. Karyn, just very quickly before we let you go, I mean, another issue, a court challenge to the reopening of schools, Mmusi Maimane and One South Africa movement. The Education Department scathing on Mmusi Maimane's legal bid, and its argument is that evidence from, other countries is that children from 0 to 19 are less likely to catch COVID-19. But what bearing will the already reported infections at schools have on this case?
Well, Mmusi Maimane yet to file a replying affidavit in this case. No doubt he will raise that issue. We have also seen a number of teachers coming out and saying it's not just about the children, it's about the adults in schools and the dangers to them. There have been reported incidents, for example, of teachers being subjected to COVID infections. So those issues will be raised. What's interesting with this case is that government is seeking a punitive costs order against Mmusi Maimane and the One South African movement movement on the basis that they brought this application so late. They say they've known since the 30th of April that governments plan to reopen the schools, and they only brought this application on the 30th of May and should therefore be punished for it. Also making the argument, Griselda, that the expense of children, for example, repeating the school year could end up costing the education department in the region of 22 billion rand, and that's just for classrooms. So trying to say on a cost-benefit analysis and for the future of particularly South Africans' poor school children, this is simply a decision they had to take.
Karyn, thank you very much indeed for your time. Senior legal journalist Karyn Maughan joining us this evening. Two of our top stories there, of course, judgment reserved in the tobacco ban case, which went to court, and of course the schools' challenges that are still expected to go to court. Let's take a look now at some of the headlines that we have for you this evening.